Honorable judges of the justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. Exciting to see so many students in the audience today. Would like to take just a moment to have each of the groups introduced if we could. Ms. Jacobson, would you like to come forward for? Yes, please. I thought you had this all routine. I'm sorry. I should have been more explicit.
Well, we have
I'm
new
sorry.
chief, so I'm just checking. If it may please the court, Madam Chief Justice, I'm Connie Jacobson. I'm the government teacher this year at Topeka West High School, which is the alma mater of Justice Rosen.
We know.
And,
I had to tell them that, yeah, you appear here more frequently than some of the council that are here today.
Yes.
That are here
Well,
frequently.
remember
And
last?
It's
Yeah.
great to have you here.
Thank you.
Connie.
Thank you so much. You've been very, very gracious to us.
We understand he greeted you with his banner outside
Yes.
instead of bringing it into the courtroom.
Yes, a
today.
little bit
So
impartial. Are any of the attorneys from West? Because that's what happened last time. That was
That's
like
right. We had
the
to.
stars aligned. That was
They're
amazing.
shaking their heads no.
Okay, all right. Well, that's okay. Okay. Yeah, neutral there. So we thank you very much for your hospitality and being so gracious to us. Thank you very much.
Good to see you, Ms. Jacobson and fellow Chargers. Good to see you.
Good to see all of you. And then we also have a group from Wichita, Ms. Garcia.
Hey, please, court. Good morning. My name is Marisol Garcia. I'm co-chair of the Grow Your Own Lawyer program in Wichita. I'm also here with Olivia Black, who is also recently graduated with me from KU Law. I was in Justice Siegel's appellate advocacy class and had the opportunity to do an oral argument in front of Justice Standridge now back in, I believe, 2021 or 2020. And basically the Grow Your Own Lawyer program exposes high school seniors and juniors to the legal profession. From my understanding, the program has been visiting the Kansas Supreme Court for several years now, and we thank you guys for having us today.
Welcome to all of you. We look forward to Zoom with many of you later today, and we appreciate that opportunity as well. For some of you may not be very familiar with how the court functions, so I want to take just a minute to explain that as we hear oral arguments today, the court has already received briefs in the which include arguments made by the parties, and we have reviewed those. We also have, as you well know, this doesn't look like the typical courtroom you see on TV. We don't have a witness box in our courtroom. We don't have a court reporter. Those things happen at the trial court level, and we are reviewing those. So what we see is the written transcript of what happened at the trial court, what those witnesses said from the witness box and that type of thing. We give deference to the findings of fact of the trial judge who sat there and listened to that evidence. We are just reviewing the issues of law primarily that arise from that, or determining if those facts were sufficient to support the claims of the parties. So we have reviewed that court record, and we've otherwise prepared for the morning arguments. We've got lots of notes on our computers, lots of documents on our computers or on in notebooks or otherwise. So we'll be looking at things. As we do that, we are still paying attention to the arguments. We are just using those tools to help us assimilate the arguments that the attorneys are making to us. That I will ask Mr. Doug Shima to please call the morning docket.
Thank you. The first case on the 9 a.m. docket for Wednesday, March 29th, 2023 is appeal number 124064, State of Kansas versus Darylyn Michael Johnson, Shawnee County, briefs both sides.
Good morning, and may it please the court. Grace Tran of the Appellate Defender Office on behalf of Mr. Darylyn Johnson, the appellant, present and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm present, ready for argument.
Second case is appeal number 124804, State of Kansas versus Michaela Lee Spencer, Sedgwick County, briefs both sides.
Morning, may it please the court. I'm Ryan Enger, Assistant Appellate Defender. Here today on behalf of Michaela Spencer, defendant appellant in the present matter, present ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. This time I'd ask the attorneys in 124064 State v. Johnson to come forward.
Good morning, and may it please the court. Grace Tran of the Appellate Defender Office on behalf of Mr. Johnson. Your Honor, may I reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
We are here today because process matters. Mr. Johnson entered into a plea agreement in this case where he agreed to an upward departure sentence. However, Mr. Johnson was never informed of, nor did he waive his right to have a jury hear and decide the upward departure sentencing factors beyond a reasonable doubt. For that reason, Mr. Johnson is serving an illegal sentence because he is serving a sentence that doesn't conform to the applicable statutory provisions, which are KSA 21-6815 and 7. And for these reasons, we would respectfully request that Mr. Johnson's sentence be vacated and this case remanded to the district court so the district court can adequately inform Mr. Johnson of his rights. First, under Kansas statute, Mr. Johnson has a right to have a jury hear the upward sentencing departure factors and decide them beyond a reasonable doubt. This is codified in KSA 21-6815. It states that any fact that would increase the sentence beyond the statutory maximum has to be submitted to a jury. And not only that, KSA 21-6817 contains the specific law in relation to upward departures. And section B4 states that the jury trial on the upward departure factors can be waived in the manner that a jury trial can be waived. But that is exactly what did not happen in this case. So,
Well, what did happen? Didn't he, as a part of the plea, stipulate to the factors that the judge or jury would have to find for the aggravating factors to upwardly depart? Didn't that occur in the plea?
that's correct, Your Honor. Mr. Johnson did stipulate to the factors. However, he was never informed of his right in the very first place, as is required by statute. And so
Well, he could have stipulated and then the judge informed him, you understand you have a right to have a jury to decide these compelling factors or these factors, and you're waiving that right by stipulating that could have happened.
that could have happened, but that's not what happened here. Nowhere in the plea agreement nor during the plea proceedings did Mr. Johnson ever hear the district court inform him that he had a right to have the jury decide these factors before he stipulated to them.
So what would happen here is that under your theory, we would remand it back and then stipulation would still be there that he, maybe it would or wouldn't, but let's say it is. So then the court would apprise him of his right to have the factors and then impose the sentence. Is that what you're suggesting happens?
Your Honor, it's our position that the stipulation and the sentence that was then imposed was illegal because he was never informed of his right in the first place. And so that needed to happen. And according to statute, before the judge can accept or can make the departure findings, the waiver has to occur, and that's under 6817B4. And so
Wasn't there a
because,
waiver in this case, though?
sorry,
Wasn't there actually a waiver, a general jury trial waiver?
yes, Your Honor.
Why
Mr.
isn't that sufficient to waive the right to present all factors that might increase the punishment?
Your Honor, this court has found in several cases, Duncan, State versus Horn, that a general jury trial waiver before a person enters into a plea agreement is not sufficient for that person to waive their right to a jury trial on the upward departure factors specifically. And I think that makes sense when we see that the statute says that they have to waive their right to a jury trial in the same manner that they waive the right to a jury trial on the departure factors in the same way that they waive the right to a jury trial generally. And this court has said that you have to be specifically informed of the rights that you are in fact giving up. And so Mr. Johnson, although
Oh,
he,
How granular is that requirement of being informed? For example, would a defendant, before a defendant could knowingly waive his or her right to a jury trial, would they have to be informed that, let's say they're charged with a crime that has 5 elements? Does the court have to specifically name each element in the waiver proceeding?
Your Honor, I believe that this court has not gone so far as to set out a granular checklist of everything that the district court must say to the defendant before they can be adequately informed of their right. So I don't know that it would be necessary for them to say, these are the 5 elements, but generally we see in plea colloquies, you have the right to a jury trial, you have the right to testify, you have the right to remain silent, and things of that nature. And so I think here, when we talk about departure factors, if the judge had said, you have the right to have a jury decide these upward departure factors, if you wanted to exercise that right, I'd impanel a jury, the state would present evidence to them. I don't think it has to be granular, but I think here there was nothing, not in the plea agreement, not in the plea hearing. There was no mention of his right to have the jury decide these factors at all. And I think that's why the sentence is illegal. It doesn't conform to the statute.
If we get to the so what folder on this problem, why can't we go to harmless error like we do on so many other statutory process rights, rather than just having to void everything that happened after?
Your Honor, so in this case, the issue is he was never informed of his right to a jury trial, and he didn't waive that right. In my research in the case law,
Statutory right.
sorry,
Statutory right.
the statutory right under Kansas statute. I wasn't able to find a case where, in terms of the issue of a jury trial waiver, this court had applied harmless error. Now, I know that's complicated by the fact that we're talking about the statutory right now, not necessarily the right under the Constitution. However, and I think this gets into the issue of Duncan, where this court in Duncan recognized that the statute is a codification of the person's right under Apprendi. And that's why Duncan analyzed the situation in the constitutional manner. And so I think it makes sense to apply the constitutional standard here, since it's the codification of that protection of the rights. And so I don't think that a harmless error standard should apply for that reason. But even if this court were to apply harmless error here, we're not able to say what Mr. Johnson would or would not have done had he been adequately informed of his rights. And so I don't think we can say that it was harmless. It would be like saying, if someone entered into a plea agreement and they were never informed of their right to have a jury trial before they took a plea, if we said, well, this is what he wanted, he agreed to it, he pled guilty and admitted these facts, we don't say that that's okay and that that's harmless, because we understand that the right to have a jury trial is very important in this state and in this country. And so we don't just say that it's acceptable to not even inform a defendant of those rights in the very first place before they enter into it.
That's a fair comparison, but is it it isn't an exact fit, is it? Because of the fact that this defendant has heard in general without an exception being made by the judge. What I mean by that, you have a right to a jury trial. It wasn't that you have a right to a jury trial to determine your guilt. It was just like, you have a right to a jury trial. You have, the right to require the state to meet its burden of proof. It wasn't, you have a right to meet that burden of proof, except on, there was no carving out. And while I agree with you that that's doesn't necessarily mean the statute was met. Does it factor into the harmlessness analysis? That in general, he had this understanding of the right to jury trial, the right to have the state put on the witnesses, to require them to put on witnesses to meet their burden of proof, et cetera.
Your Honor, no, I don't believe that that helps in this case because, well, first, this court's case law says the exact opposite, that a general informing of the defendant about their general right to a jury trial on guilt or innocence, that doesn't cover them being informed of the right to have a jury trial on the upward departure factors. And again, I think that makes sense because while it's true that the district court, didn't exclude anything in their informing of him of his right to have a jury trial on guilt or innocence, I don't think that, someone in Mr. Johnson's position would automatically know that they have this right in the first place to have a jury decide the upward departure factors. So I think it makes sense that we need to have courts informing them of that right specifically, and informing of the right generally is just not enough.
Did he waived his right to a jury trial on guilt, correct?
That's correct, Your Honor.
And in that waiver, did it talk about the guilt portion in that waiver? Or it was just I waived my right to a jury?
Your Honor, I'm not sure of the exact specific language of the plea colloquy. There was no mention ever of upward departure factors, whether or not the judge said you're waiving your right to have a jury decide your guilt or have a jury trial. I'm not totally sure of that language, Your Honor.
And in this case, we have a specific statute that talks about convening a separate jury when if someone pleads guilty, then the statute talks about convening a separate jury for the upward departure, right?
Yes.
Okay, and then if, and I do understand what you're saying about that the statute codifies Apprendi, and I think that's clear from our prior case law. And I think in Dickey, this court used the word constitutional underpinning or constitutional overlay. So I also see what you're saying about that it wouldn't be necessarily subject to harmless error. In that sense, could you compare it to if you have a defendant who confessed to the crimes and there's no challenge to that confession, but was never advised of the right to have a jury make a determination about the facts to which the defendant confessed? Would that sustain a challenge? I mean, would we say that was okay?
Your Honor, I see that I'm out of time. Chief Judge, may I answer the question?
Yes.
I would say that that's a comparable situation. And I believe a relatively recent case, State versus Johnson, looked at that issue where the defendant had perhaps admitted to one of the elements on the stand. And this court had found that because that defendant did not get, the judge did not inform them or get a waiver of their right to have the jury decide that factor before he admitted to it, that was error. And then that had to go back. So yes, I would say that it's the same thing that should happen here. And Your Honor, for these reasons, we would request that Mr. Johnson's sentence be vacated.
Chief, may I ask a question? Assuming that the general admonition is given by the judge, the trial court judge, you have the right to a jury. What is the effect of having an attorney? No, they do have an attorney, and the attorney is going to know about how sentencing rules apply. Going off what Chief Judge Lukert said, can we combine those two things in deciding whether or not the defendant has been adequately advised and whether he's going into the harmlessness analysis?
So, Your Honor, I don't think we can combine any advice that an attorney may have given their client with any admonition that the district court might have given. I think specifically pointing to the statutory language in 2168-17 B4, where it talks about the waiver of the right to a jury trial has to happen in the manner of KSA 223404. So that's the way that they can waive a right to a jury trial. In that context, we don't say, we say that the district court is the one that has to inform the defendant. It doesn't really matter if the defendant's attorney has already said it to them. The plea colloquy and the advising of the rights has to come from the district court. So I think because the statute says that this has to happen in the same manner, that we would also hold the district court to informing the defendant of those rights.
Since you asked, you just touched on a question that I had under the statute, the waiver statute under 6817 refers you back to 223403. Let's just assume that we're looking at this as an issue of first impression, right? I know that you mentioned some of the case law that we've had to interpret this, but what about 223403 did not happen with this waiver? Or are you suggesting that we have to look at 14th Amendment, Sixth Amendment principles to overlay that onto 223403 to find a statutory violation? I mean, if you look at the plain language of 223403, I mean, it's really just both parties submitting it to the district court.
Right, Your Honor. And so your question is disregarding previous case law that has interpreted that statute?
Yeah, if we were just looking at this or fresh, if we just look at the statute itself and don't look beyond the language of the statute, do you think that there's a violation, or is your argument dependent upon maybe some ambiguity or just some sort of statutory interpretation principle that requires us to overlay the constitutional principles?
Well, I mean, firstly, the statute itself, not 223403, but 2168-17 B4, it talks about that the proceeding for the jury may be waived. And so I think that we have that statutory language to go off of. In terms of the specific language of 223403, I do think constitutional principles overlay that when we look at it to see what process is due to the defendant when they are waiving this, very important right to have a jury trial.
Questions? Thank you, Mr.
Thank you.
Chalmers?
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I don't even struggle on that one. All right. In the plea agreement, Johnson asserted by pleading, there will be no further trial of any kind, either before a court or a jury. And I further realized that the court may impose the same punishment as if I had pleaded not guilty, stood trial, and had been convicted by a court or a jury.
Sorry, Counsel, could
Yes.
you read that back to me real quick?
Sure. It's record 1-352. It's on page 3 of my supplemental brief, and I think I have it. I'm sorry, my original before the court appeals.
But read slowly.
Yeah, I can try that. By pleading, there will be no further trial of any kind, either before a court or a jury. And I further realize that the court may impose the same punishment as if I had pleaded not guilty, stood trial, and had been convicted by a court or a jury.
Two questions about that. Number one, wouldn't you agree that where does that contemplate a punishment that goes above the guidelines?
It does not specifically deal with that, but the Apprendi issue is that it's a sentencing factor. It's treated like an element. So I don't understand, and I know this court has said in Duncan that there has to be a special waiver. I don't understand why. It's an element, essentially. We don't require special element waivers for anything else. He was
Okay.
told he has no right to a jury. I don't know that he had to.
In Duncan, would you agree in Duncan that the record needs to demonstrate what specific right or rights that the defendant is waiving? And in Copes, we said, in order to satisfy due process, a waiver must be an intentional abandonment or relinquishment of a known right or privilege. So it needs to be specific, right?
I agree that Duncan has said that there has to be a specific waiver to an upward departure. I think when you waive the right to a jury trial, you waive a right to a jury trial. I'm still today lost at how this is a statutory error. I don't think this court has jurisdiction, and with all due respect, I think that Duncan was wrongly decided.
So you would say that your argument is that Duncan should be overturned. So
Yes.
under our existing case law, you lose, right?
No, I do not lose under our existing case law because Duncan didn't engage in a harmless error analysis. The facts of this case are different. He not only knowingly stipulated, he testified at sentencing. Yes, these factors exist. At that point, there's no constitutional violation. There's no Apprendi violation. If a defendant admits to the fact, he doesn't challenge the fact, there doesn't even need
What
to
about
be
a
a jury trial
statutory
waiver.
violation?
And I'm not sure what statute this court thinks was violated. And that's why
Codification of Apprendi.
the codification of Apprendi requires a jury to hear the factors, but it doesn't require a jury trial waiver specific to an upward departure. All the statute says is have a jury trial waiver and do it under 22-3403. 24-34 in the same manner as provided for a jury trial. That to me suggests that when you waive your jury trial, you waive your sentencing
Counsel,
on the upper, yes.
I think the argument you're making has merit. Whether or not it would ultimately prevail, we'll wait and see, I guess. But I think there's merit to the argument that a general jury trial waiver really does encompass every factor that constitutionally must be proved to a jury. That makes sense to me. That's a background to my question, which is in this particular case, in this record, I think there's a wrinkle that bothers me.
Okay.
And that is that the judge, in fact, does talk about maximum sentence during the plea colloquy. And actually, I mean, really does a nice job. As I read the record, at least, the defendant has the sentencing guidelines in front of him. The judge is going over, explaining how the boxes work. But then the judge says, and the maximum I can sentence you to in this case, if you plea, is 130 months. Does that change the analysis? Because that's not the sentence he got.
No, Your Honor, because the plea deal in this case was specific on an upward departure. It was, they said.
I
the
understand
agreed
that,
upon
but the
sentence-
judge tells the defendant, the maximum I can sentence you to is 130 months.
Right, but we know the
And
defendant,
that's right in the middle of talking about the jury trial waiver. And I guess, can you at least acknowledge that that
is not ideal, sure. That I would have liked the judge to have, I don't know, paid attention better to the plea agreement to know there was an upward departure here and mention the upward departure statute, absolutely.
Well,
But
if
I'd
you're the
like-
defendant, and if we are engaged in protecting the defendant's rights, it strikes me as pretty commonsensical that if a defendant hears that from a judge, right in the middle of the judge discussing the jury trial waiver, the defendant would think, I guess I can't be sentenced to more than 130 months. The judge just told me that.
But we know from sentencing that he knows he can be sentenced to more than 120 months. He goes on the
I think that
stand.
we
he
should
talks
just
about-
assume that the defendant
I think we should,
thought
assume-
in his, oh, that judge is wrong.
I think we should assume defense attorneys are competent.
That's a different issue.
It is, but the defense attorney is competent. He had a binding agreement with the state that said, I agree to this upward departure. I agree to these factors. I agree to 180-month sentence. At that point, by statute, this court has no jurisdiction to hear this case. This is an agreed upon sentencing case. The only way this court has found its jurisdiction is State v. Duncan. And State v. Duncan, as far as I can tell, raises constitutional issues. I'm not aware also of any case law by this court that has said that the jury trial waiver requirement is anything other than a constitutional requirement. Maybe if there is that case, they haven't cited in their brief. I'm not saying it doesn't exist. I just don't immediately know. It looks like this court just blends the two together, has the constitutional and the statutory requirement discussed at the same time.
I'm a little confused here. You said that we don't have any jury, we're bound by what the state and the defendant agreed to. That's not accurate. The court itself is not bound by any plea
Your
agreement.
Honor, for jurisdiction, yes, if there's an agreed upon sentence that the court approves, this court has no jurisdiction over a plea.
But the sentence imposed is always to the discretion of the court. I mean, the court could have downward departed.
Absolutely. And the court recognized that. They actually could have gone above what the state asked here or below. But I'm saying for this court to have jurisdiction, there's a specific statute that this says, KSA 216820C2 bars appellate courts from considering any sentence resulting from an agreement between the state and the defendant, which the sentencing court approves on the record. That's what I'm saying when there's no jurisdiction, Your Honor.
So in a situation where the defendant agrees to aggravating circumstances or stipulates that don't have any factual basis at all, your position would be the same.
Absolutely, unless the sentence is illegal. And the only reason this court reached the issue in State v. Duncan, I mean, there's no jurisdictional exception for factual error. But the only reason this court reached the issue in State v. Duncan is they found it was an illegal sentence. This court found it was an illegal sentence, but this court did so based on constitutional grounds. And this court is well aware that it has numerous cases saying constitutional issues cannot be raised through a motion to correct a legal sentence. But I think I respectfully, sorry.
I don't understand how, but Dickey, what about Dickey?
Oh, I've been asking your court to overturn Dickey for years too.
But Dickey, right, you disagree with Dickey.
Sure.
But Dickey was an illegal sentence and based on Apprendi, right? Because it was a constitutional overlay.
And since Dickey, this court has repeatedly said Apprendi issues cannot be raised through a motion to correct a legal sentence. Dickey is an outlier.
But here
Duncan
we
is an
have a
outlier.
statute. We have a particular statute that codifies Dickey or Apprendi in this context that applies to this situation. It's almost like you're not even taking that into account.
I don't see a statutory violation here. He stipulated, he waived his jury trial right. The statute says you can waive your jury trial right
But
in
he didn't
accordance with.
specifically waive his jury trial right to have a jury decide aggravating factors.
I agree with you, but I don't think there's a statute that requires that. And unless there's a statute that requires that, there can't be an illegal sentence
But
here.
our case law says when you're waiving something, it needs to be, first of all, you need to be specifically advised by the court of what you're specifically waiving, and you need to waive that specific right.
Typically, it just has to be advised that you have a right to a jury trial.
I think maybe there's a slight distinction here in that he waived it. The question maybe, was it a knowing waiver? And perhaps that's where we get into, is that a constitutional requirement or a statutory requirement or just a common sense requirement that you can't truly waive if you don't know what you're waiving?
And I think that has been a constitutional requirement. This court has read it into the Sixth Amendment. And that's where you get your case law saying that you need to do all of this. And again, you can't reach that issue here because there is no jurisdiction. But even if this.
What if there had been no waiver at all? Would we still not, how would that impact your jurisdiction?
If there had been no jury trial waiver at all, then the plea wouldn't have been valid and we would have to go back and do it.
But we would have jurisdiction.
And that's a constitutional issue, according to you, with no statutory basis.
I don't know that you would be able to do it on a direct appeal. You could file a motion to correct an illegal sentence, which is typically what you do when there's a flaw in the, or sorry, not motion to correct an illegal sentence, a motion to withdraw the plea. That is typically how this court gets jurisdiction. There's all kinds of case law that you can't reach issues. You can't reach double jeopardy, which is a constitutional issue. You can't reach basically anything until there's a motion to withdraw a plea on the table. So I don't think there is necessarily the ability to get it is through direct appeal, maybe through a 1507, maybe
Your view
through.
would be that procedurally, the defendant ought to have filed a motion to withdraw his plea.
If that's what he wanted to do. Here, though, I don't even think he wants out of his plea. So I don't know that he would or would not do that. He hasn't filed that motion yet, but he stipulated. And this court has also made clear that the failure to submit a sentencing factor to the jury is not structural error. What he's asking for here is structural error. And it just shouldn't be. The Court of Appeals got it right. There is actually no Apprendi error here. Again, he stipulated. That's not an Apprendi violation. The United States Supreme Court in Blakely made that clear. There is no actual constitutional error. So at best, we have statutory error that is somehow broader than the Constitution based on very vague language. Again, 22-304.
I mean, it sounds like what you're saying is what we have at best from the defendant's perspective is an unknowingly made plea. Is a defective plea agreement, essentially. Is that a fair summary of what you're arguing?
If that is what he thinks happened, then he should file a motion to withdraw a plea. He's just exercising at this point a procedural right that I just don't think he has because of his stipulation. He stipulated. He's bound by that stipulation, as the Court of Appeals pointed out. He'll be bound by it again. The worst that happens here is we go back down and he either waives the right
But
or we
isn't he
summon a
challenging-
jury.
Isn't he challenging the fact that he wasn't advised of his right? You know, so you keep talking about he's bound by the stipulation, he's bound by the stipulation. The issue is, at least the way it's been framed in the briefs and framed by opposing counsel, is I guess that's what the chief is talking about is, you know, I wasn't advised of my right to a jury trial before I made that stipulation.
He, in his plea agreement, again, what I started with, he was advised, he said, I'm not going to have a jury trial. I know
Right, but
that.
I mean, right. So
I know you
you're
want
going-
a specific,
May
sorry.
I
sorry.
continue?
Absolutely.
But his position is that that general jury trial waiver doesn't encompass, I know you disagree with that, but it doesn't encompass because they've cited cases that say that the waiver must be specific to the right and not just a general jury trial right on guilt and elements, but specifically aggravated factors that go above the maximum sentence.
I understand that's his argument. In Nieder and in Reyna, Nieder is the United States Supreme Court case. Nieder says if there's not an element submitted to the jury, if it's overwhelming, it's harmless. You don't have to be like, oh, they didn't waive or do a jury trial waiver on a very specific factor, so it's structural. They've never said that. In
But they're not
Reyna,
construing this as an element.
it is an element though. It's a sentencing element. That's the reason we have to do Apprendi and have the upward departure factor. This court in Reyna and many other cases, when the defendant says there's no element that he's over 18, it's harmlessness. I just don't see how, if the failure to submit an element to the jury can be harmless under Nieder and Reyna and numerous other case law, it can't be harmless here.
And we get to the so if we get to the harmless
Mhm.
error analysis, like we did in Reyna and other cases since that, is that the evidence is obvious, it's overwhelming. And you would say, based upon the stipulation to the aggravating factors, that suffices to be overwhelming. And
Not only the stipulation, he testified and admitted to the elements, but yes, the stipulation would make it
of the
overwhelming.
two aggravating factors
Yes,
that he acknowledged, the fiduciary and the other. Okay.
But
But
wouldn't
again, I
the
just,
question actually be, and I think the discussion about whether a motion to withdraw is the proper vehicle, maybe indirectly touches on my question, but shouldn't the harmlessness inquiry actually focus on whether or not, but for the error, we're assuming error, whether or not the defendant would have entered into the plea or not?
right. That was my question.
No, he doesn't even argue that. He doesn't say that I wouldn't have entered this plea. He
If
obviously.
we're
wouldn't have
just
entered
looking at
plea.
the proper focus of harmless error.
But I think the error here is that he didn't get his jury trial. That's what he's arguing. So that's no different than Nieder. It's no
No.
different.
But if he
That's
wouldn't
not
have
his
had
argument.
but if he wouldn't have pled, we wouldn't have had the stipulations
Right.
and that.
If he would not have pled, then he would have had a jury trial. He waived his right to a jury trial when he entered his plea.
The relief he's requesting is deem the sentence illegal, vacate the sentence and remand so the district court can adequately inform him of his right to have a jury trial on the aggravating factors.
Yes.
So the error is that the district court did not advise him of his right to have a jury trial on the aggravated factors.
And
Error is not an elements test of
how
whether
is
the
that
jury.
any different than every single time we failed to submit an element to the jury, it would be structural error because the defendant did not waive the right to find that particular element or that particular sentencing factor. That's not the case law. You can't, I don't see how this court can say this is structural error in this circumstance
You're
but-
framing the issue differently than
because he's framing it wrong, as far as I'm concerned, Your Honor.
his issue to frame.
That doesn't mean he's doing it correctly. His issue is that he had a right to a jury trial and he wasn't told. That's
No.
true.
He's saying he had a right to be informed. He had a right to make a choice.
And he chose to not have a jury trial.
He
He
was
chose to
never,
agree.
he was never informed of that.
We don't actually know that. Again, he had competent defense
Nothing-
counsel. He was never informed by the court. I will
It
admit
needs
that.
to be on the record that he was informed that he had a right to a jury trial on the aggravated factors. Show me in the record where he was informed of that right.
I didn't say he was informed of that right, Your Honor. No, I didn't. I said he didn't want a jury trial. He put in his plea agreement that he didn't want a jury trial. That to me is sufficient. I don't think we're going to perhaps agree on this ever, but my point is that when you look to what the remedy is, this isn't any different than any other time an element has not been submitted to the jury. We don't say, oh, you weren't advised that you have a right to have the jury find the element is over 18, so now that's structural error.
Yeah, they want their conviction vacated for insufficient evidence, correct? That's not the remedy requested here.
That they either want it vacated or oftentimes they just want the non-Jessica's law sentence.
Right. This is apples and oranges.
It's still the same constitutional issue though, which is that you didn't have a jury trial. You had, the Apprendi thing is that you have a right to a jury trial. You do not have a right to a jury trial when you stipulate and when you admit. Blakely says that. So there is again, no constitutional violation here, but I'm still stuck on, I don't know what statute was violated. And until this court can point to a statute that was violated, this sentence can't be illegal and there's no jurisdiction. I'm sorry, I'm way out of time. Is there any further questions? I'd be happy to attempt to answer them. Thank you.
I have a couple questions. I'm sorry to drag you back up. And it really goes to remedy. You heard the discussion. What is the remedy you're seeking?
Your Honor, the remedy that we're seeking is for Mr. Johnson's sentence to be vacated, this case remanded back to the district court so that he can be adequately informed of his right to have the jury trial on the aggravating factors.
And then would he plan to not waive that jury trial right?
Your Honor, I can't say what Mr. Johnson would do once he's been adequately informed of
But
his
let me
rights.
ask hypothetically, if you get the remedy you're seeking and it goes back and the defendant says, I want a jury trial. Isn't that effectively a motion to withdraw his plea? That's what I'm driving at.
Your Honor,
Because it seems to me that is exactly what the posture of this case truly is I want to withdraw my plea.
Your Honor, first, what I would say in response to that question is that Mr. Johnson can't agree to an illegal sentence. And that's what happened here, is that the statute wasn't followed, and so the sentence is illegal. So regardless of the plea agreement, he can't agree to a sentence that's illegal. Once it goes back to the district court and he's properly informed of his rights and he has competent counsel with which to make that decision, we can't say what might happen at the district court. If the state wants to move to withdraw their plea, they may be able to do that, but at that point, that's.
Why would the state have to do that? I mean.
Well, if the state feel that Mr. Johnson's actions would be a violation of the plea agreement, if in the hypothetical event that he did want to exercise his right to a jury trial.
Let me ask a question. So, since we're just talking about a jury trial on the aggravated factors, if it goes back down, the plea agreement is still in place. His maximum sentence is 130 months. And the only issue for the jury is going to be the aggravating factors and whether it can go above the 130 months, right?
Yes, Your Honor.
Didn't
So
he,
it's not withdrawing the plea to the guilt phase. It's just the aggravating factors. So he's not withdrawing his plea. It just allows him to decide whether or not he's going to hold the state to prove the aggravating factors, correct?
Yes, Your Honor.
well, let me ask about that. And I ask in genuine ignorance, so you can correct me if I'm wrong. But my understanding is that the plea agreement includes a plea to the aggravating factors and to the sentence and to the departure sentence. That's my understanding of the plea, that it's not just to guilt and the sentencing grid box, but it's to the aggravating factors and the enhanced departure sentence. Am I wrong about that?
No, Your Honor, that's correct.
I know you and Justice Wall explored this a little bit, but I kind of want to return to 223403 and the language it uses, which does not include the word waiver. Basically is just the defendant may submit the trial to the court. So in your research, did you find any cases that focus on 223403 as requiring formal, some of the things that we do impose under the constitutional standard for a knowing waiver?
Yes, Your Honor, I would point this court to State versus Beaman 2012. I believe that was
Beaman, did you say?
Beaman. That case, when it's talking about this issue, I think that was just a general jury trial, right? But when it says, waiver, KSA 223403, that the district court has to inform the defendant of the specific right, and then the defendant has to clearly and unequivocally give that right up. So going toward, it must be a knowing waiver because the district court has to inform them exactly what they're giving up beforehand.
You happen to have a site on that, Beaman?
Yes, Your Honor, 1 second. 295 can 853.
Anything else, Ms. Tran?
No, Your Honor, thank you.
Thank you. Thank you to both counsel for your arguments in this case. The court will now take this matter under advisement. By that, what I mean is that the court will begin discussing the outcome in this case today. And we will continue that discussion until there is a written decision finalized. There will be a announcement by the court that that decision has been filed. And you can read the final written decision on the kscourts.org website. Thank you, counsel. Now call 124-804 State v. Spencer.
Morning, may it please the court, Ryan Eddinger, Appellate Defender Office. Here on behalf on McCalla Spencer today, defendant appellant in this case. If I could request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Sedgwick County jury convicted McCalla Spencer of 1 count of premeditated first-degree murder, 1 count of theft, and 1 count of selling sexual relations. The district court thereafter imposed a hard 50 sentence. There are 2 issues here this morning before the court that I would like to address, and unless the court would direct me otherwise, I would like to focus my energy this morning on the claim that Mrs. Spencer's statements, despite the issuing of Miranda warnings, were not made voluntarily due to the circumstances surrounding her interrogation. As this court knows, there's several factors to consider in this analysis. One of which, and I can just list them quickly, the accused's mental condition, the manner and duration of the interrogation at issue, her ability to communicate with the outside world upon request, the accused's age, intellect, and her background, the fairness of the officers in conducting the interrogation, and the accused fluency in the English language.
Before you get too far down that path, can I ask you a question? Do we even need to get that far? I mean, even if we didn't take into consideration the admissions or the confessions, why isn't the other trial evidence sufficient to support the first degree murder charges? Or where's the gap in the evidence that requires us to have to rely on the confession to find that there's sufficient evidence?
Are you I suppose in some way you're asking me whether, even if you were to, you're asking me a harmlessness question?
Yeah,
Basically,
essentially.
Is that essentially
Yeah,
what you're
yeah, I
asking?
think so.
What I would argue here is that with if these statements don't come in, if this interrogation doesn't happen the way it does, and she's not put in this position, this coercive environment, a situation where she's been sleepless for well over 24 hours, it looks like 48 hours, has just come off of an obvious meth fueled binge, and is given an opportunity for counsel, I think the whole framing of this entire case could be completely different. I would submit that the court's well aware of the background circumstances and the accusations that she was making, that basically all of the facts that are there, that the things she spoke about during that interrogation. And I don't really necessarily feel at liberty to go completely at length into those, as they weren't proven by any means. But I think that's the critical point. I think if she has counsel and asserts her right to counsel, at that point, that this case could have turned out completely different. I think she could have had, she'd get an opportunity to build some kind of defense. That
I'm not sure I follow that. And I kind of agree. There's a little bit of a chicken and egg problem that I've had with this, because let's assume you lose on the voluntariness of the confession issue.
can you say it one more?
Assume you lose, then clearly there's sufficiency, right?
You're
I think-
asking about sufficiency to support premeditation. Is that what you're asking?
Yes.
I've made the argument that there is a question here, that a reasonable jury could have looked at that and said that it was lacking in premeditation. She did explain that the original reason for this was not, there was no, I know it was the state's theory in this whole thing that, and I know Detective Palmer made it very clear that that was what she believed was the situation, that this was a planned event, that the plan was developed beforehand, well beforehand, in reaction to the trauma that my client has allegedly sustained at the hands of the victim in this case.
But let's get back then to Justice Wall's question. If we just, I guess I just want to know why there isn't sufficient evidence, setting aside the voluntariness of her statements, why the evidence put on by the state isn't sufficient to justify the conviction on premeditation.
Even in the you're asking me that even in the absence of anything, any evidence that came in as a result of her testimony, why? Because is that what you're asking?
Yeah.
Let's pull her all the evidence at trial.
All of her admission. I mean, but just
all
her
the
admission.
evidence at
You've
trial
still got a
about,
recording, you've still got, I mean, you've got a lot of other evidence here.
yeah.
I got a lot of evidence. I'm just saying, and that's what I think Justice Wall's getting at is
And I understand the question.
is absent absent her statements to police. Why isn't the rest of it enough?
I would say it's like you said, it's kind of a chicken and egg problem. It's not, I would argue it's not enough because there is a tremendous amount of, there's a very first thing that a juror commonly thinks of when you get to the question of premeditation is it's planned beforehand. Well, during this whole interrogation, Detective Palmer basically elicits this idea that this, even though my client refutes that notion, she says this originally, all I was doing was going there to exchange sex for $40 in marijuana. That's what she repeatedly says during her interrogation. Well, Detective Palmer basically puts it out there and at one point is like, I know you had a plan. I know that you did this and sets it up in a way that makes a lot of sense to most people that want to hear the story. You have a beginning of the story, you have a terrible event that happens allegedly to somebody, you have the end of the story. It's as the state argued, it's a revenge story, and that speaks to people. So I think it's problematic, or you can't pull everything from her testimony or from her interrogation, all that evidence out of the trial. And basically what you're saying at that point, Your Honor, is the video is enough. If I understand what you're saying.
Well, I'm
Because
just saying that's part of the evidence, but I think there's a lot of other evidence, but there's the exchanges of the text messages on the phone,
Right.
plus a recording,
those-
there's a recording of the killing, which,
Precisely, that's what I'm saying.
and
It's-
that's coming in.
Absolutely, and I understand your point completely. What you're saying is that essentially the text, and I point out, I guess, that's important, the text messages, she gave consent to have her phone searched, I would say, there was no motion to suppress, but she gave consent to have her phone searched during that interrogation. And she does it in a manner where very reluctantly.
But we
let's
don't
say.
get to get to that because.
Well, I think if we're going to talk about the text messages and how they got into trial, then
But there has
we
to,
have to talk
but we
about
have
that.
to, we have to move to suppress to make that a legal issue to.
Right,
Yeah,
but, and
that's the
again, it
problem.
wasn't, I'm just saying that.
We have the
it-
number
it
of,
did
we
come in
have
that
what,
way.
14 stab wounds, there's evidence here that a jury could look at and say, yeah, that's premeditated without even thinking about her statements.
It could, but I don't know that we can say beyond a reasonable doubt that they would. Is the only response I can provide. And I think, and I do understand the question that even in the absence of everything that happened in this interrogation, but I think that's really how I have to answer the question. If this is I think this could be a completely different situation if she's able to build a defense. If she's not placed in an interrogation room at 3:33 a.m. in the morning of, I think it was May 13th. She's been sitting in that room for 7.5 hours before anybody comes in. The detective comes in at 3:33 a.m. She knows she's been, like she said, she's seen the trailer, the accused mental state. She says she's been doing meth. She doesn't say she's acutely under the influence at that point in time. But when you watch the interrogation, there's multiple times where she sounds incoherent. She says, I don't remember. She says it was just a dream. So there's a number of factors here that I think I pointed most of them out.
She acknowledged to the officers that, I wrote them down here, she provided her biographical information, her current and previous addresses, her date of birth, her social security number, her height, weight, medical history, her mother's phone number.
All right, and those are sort of
And what the court
administrative
found,
things.
but in what the court found to be the district court found to be in a clear and coherent manner. And our standard of review is whether, there's substantial competent evidence to support the factual findings of then whether the law applied to those. So,
Well, de novo.
and we're not allowed to reweigh the evidence. So the question is whether looking at that tape, looking at what the officers testified to, whether there's substantial competent evidence to support the district court's conclusion. I know you know that. It's just, I think there's another side to this that supports what the district court seems to be finding, unless you've got some other reason, why.
Well, I think I'm arguing that the court actually had substantial competent evidence to toss this interrogation. And instead of allowing it to come into evidence, to suppress it and keep it from the jury. The court watched the video. The court had to see that, she made the same admissions. If the court's basing the fact that she knows her address and that's substantial competent evidence to say that she's made a full and voluntary knowing waiver of her constitutional right against self-incrimination at 3:33 a.m. in the morning from 7 a.m. in the morning. To the extent.
Distinguish this from other cases, which in my mind, over the years, we found perhaps someone who's being questioned under greater influence and maybe stumbling and kind of regains composure. How does this fit in like the Galloway analysis and some others where there was even perhaps greater evidence of intoxication and we found it was still voluntary? I don't see this as an extreme outlier anywhere. It kind of fits in those cases.
I'd say it's difficult. I agree. And the standard is the condition has to render the defendant confused, unable to understand, unable to remember sort of what occurred. Those are the things that Galloway.
And exactly. And what Justice Miles just touched on, what the court found was, yeah, certain basic questions was able to comprehend and able to comprehend the events that took place. I'm just not seeing where it fits outside of that analysis.
Absolutely. I can address that for you, Your Honor. Like I said, and I think I'm more or less sort of repeating the same thing at this point. I apologize for that, but that's what I have here. She, those are the standards. Was she confused? Was she unable to understand, unable to remember what occurred? And I think that you have to drive it more than I know my address. I know where I'm at right now. You have to get into the substantive things of what were really the actual admissions of guilt here and what she was saying. And there's plenty of statements throughout that entire thing where she says, I don't remember. I'm really confused. Number of times where I'm so tired. I'm so tired.
And again, it fits. Those fit within some of the facts of Galloway and other cases. It just seems to me. And I understand that you're the hurdle you've got.
Okay. And so that's all that I can ask the court to
Let me
look at.
move you to the second interview. And I realize your legal argument is the first taints the second.
Absolutely.
Let's forget about the law for a second. And just as a statement of fact, clearly it is competent and coherent at the second interview because she's had plenty of time to sleep. She's been in jail. She hasn't had, access to any drugs. The evidence suggests she hasn't had anything, and she tells the same story, basically. So as a question of whether the conditions of the first interview cause us to be concerned about the accuracy of what was said.
Well, I think it's
factually, there were no changes. Now, I understand the legal argument about free and all that stuff, but I don't want to talk about the law. I just want to talk about what does that tell us about the voluntariness of what she said the first time?
Well, I think, and I don't think how you can get around the question of taint if you're asking about the voluntariness. That you understand? I don't know how you look at it in a vacuum and compare it to the first one without that first interview having an effect of what she's saying in the second and whether she wants to talk at all. And I point out that during the very beginning of that interview, and I think this is indicative of her pretty much feeling like it is showing that from the first one, I really don't have much choice in this matter. Before Detective Palmer puts the Miranda form on her and in front of her, and she just, or she can even read it to her. And so I think that's, in that second interview, that's pretty clear evidence to me that this has been affected by the first one, and this is just a continuation. It's really not subsided. I see that I'm out of time, unless the court has additional questions for me. Thank you, Your Honor.
Thank you. For Maloney?
May it please the court, Assistant District Attorney Matt Maloney for the state. This is a rare case, Your Honors. I think that any of us who have done criminal law for any amount of time have certainly come across cases where we have perhaps grainy surveillance footage of a murder or part of a murder. But it is extremely rare to have the quality of audio and partial video footage of a murder as it's happening. And while I realize that counsel today didn't really argue the sufficiency argument, I think it's nevertheless important to focus to some extent on that in recapping the evidence here. We have a situation where we had overwhelming evidence of direct evidence of premeditation in this case. We have those text messages between the defendant and her boyfriend showing that this was very much a choreographed event. We have the Facebook messages that she sent to the victim for the 2 days leading up to this, that shows that she very much put this plan in place, that she was adamant that her male friend be allowed to come, which is further indication that she knew that this wasn't just going to be a sexual encounter, that she was wanting him there for help with the murder. And then, of course, we have the video and the audio of the act itself, where we hear the defendant's own words as she is stabbing and participating in a stabbing of the victim, where she is saying, go for the heart, make sure he's not breathing. Is he still breathing? Is he still alive? I think he's still breathing. So we have overwhelming evidence of premeditation even before we get to the statement. And that is to return to the questions that this court asked opposing counsel with respect to whether there would be a harmless finding if you were to find that the statement was somehow involuntary. But I want to make clear that our position, as argued in the brief, is that the district court was absolutely correct, that this was a voluntary statement. And I added the video of the interviews to the record because, first of all, it's always the best evidence when you're looking at the voluntariness of a confession or a statement. And I think it's always important when that video is clear and easily understood to have that before you so that you can press play and see exactly what was going on in that interview room. But it's also important in this case because it clarifies the timeline. And that's an important part of the defendant's argument. Essentially, the argument that the defense raised in the brief is two-pronged. One, she had used meth, and two, she hadn't slept for 2 days. And I think at one point in the brief, he even says she hadn't slept in nearly 3 days. Well, the video directly refutes that. She was brought into the interview room at 8 o'clock on a Monday night. She ends up telling the detective that she slept on Sunday night for a few hours. Now, there was initially, I think she did make some statement about a couple of days, but then when the issue is clarified, and which is why it's so important to have the video in the record, she says, oh, I slept for a few hours on Sunday night. So essentially, she had lived a normal day. I slept last night. I think that by 8 p.m. tonight, I'll be perfectly capable of making voluntary decisions. So she hadn't gone 2 days, let alone 3 days without sleeping. She had lived less than 24 hours, presumably, since she last slept. So that's one important thing with the timeline. The other important thing is in the brief, the defendant cites the 15-hour figure in assessing the voluntariness of this statement. Well, the last 3.5 hours of that can be completely discounted because all of the interview was done before the 11.5-hour mark. The last 3.5 hours is she's simply sitting in the room, not being interviewed, waiting more or less to be taken over to the jail. So the real timeline is, yes, she was in the room for 7.5 hours by herself before the interview began. Then the detective came in. There was an hour and 40 minutes of questioning. Then the detective left the room for 40 minutes, returned for another 20 minutes, left for another 45, and then came back for the final 35 minutes. Now, during that time, during those breaks, she was offered food and bathroom breaks and water on multiple occasions. The video shows, and the defendant herself confirmed to the detective that she did in fact nap during some of the time that she was in the room by herself. So the timeline is clarified by the video. I'd also just note that simply pressing play on that video, your honors can see the same thing that the district court saw. This was not a person who was unable to make a voluntary decision of whether to speak to the officer. She was completely in control of her faculties. The defense argument is essentially that she was emotional and I think at one point used the phrase incoherent. And I would strongly disagree with that. When you watch that video, for the vast majority of the time, she is speaking about this event and about all of the questions in a very calm, organized manner. She certainly does to some extent try to minimize and say, well, I didn't really go there intending to kill him. I did go there to have sex in exchange for drug or money. But her own words ultimately betray her, as on a couple of occasions, she does refer to this as playing out like a fantasy and according to her dreams. So she's acknowledged that she did in fact think about killing him. She also, at one point during the interview, she acknowledged that when she took the knife out, she thought about where she was going to stab the victim. And then she did say that she decided to castrate the victim. So our position is that the defendant is really only focusing on the manner and duration of the interrogation. He essentially concedes that the other factors warrant a finding of voluntariness. But his position is that it's just that one factor so overrides the remaining factors as to warrant the confession involuntary. But our position is that even the one factor that defense counsel is relying on clearly weighs in the state's favor here. And as your honors pointed out, there is case law where far more extreme examples of a defendant who perhaps is actually showing signs of intoxication or drug use or sleepiness, and those statements have been found to be voluntary. And here the only reference to drugs is the fact that on the day of the murder, so now more than 24 hours earlier, that she had used meth. But by her own admission, the effects of that had worn off. And I think that's clear on the video. This was not somebody who had any trouble remembering not only the background information as far as phone numbers and her name and address, but details of the event. So our position is that absolutely this was a voluntary statement. The district court reviewed that video before making its ruling. Its findings, its factual findings are supported by substantial competent evidence, and its ultimate legal ruling is correct. So while we certainly don't believe that you need to get to a harmless error analysis because we don't think there was any error, we would also agree with some of the questions that this court asked opposing counsel. Even if you were somehow to agree that there was any problem with this statement, all of the other evidence overwhelmingly showed the defendant's guilt and showed that this was premeditated. So even if this confession were completely thrown out of court, there is no reasonable possibility that a jury would have reached a different verdict after being able to watch the video and listen to the audio of the killing, seeing those text messages, seeing the Facebook messages. The statement clearly was helpful to the state. That's why we admitted it. But even without it, even if she had gone into that interview room and refused to speak and said, I want my attorney and I'm invoking my rights, the verdict in this case would not have been different. Again, this is a rare case with the volume of evidence that we have of premeditation as far as direct evidence of premeditation. Usually you do have to prove premeditation through circumstantial evidence. But here, the defendant's own words on that audio of the murder clearly show that that element is proven. If there are no questions from the court, the state would respectfully request that the district court's ruling on the suppression issue and that the defendant's conviction be affirmed. Thank you.
Just have a couple small things that I'd like to address quickly. Number one, as far as not adding the video, or I filed a 302 to add the video from the pretrial hearing. It didn't get added, so the state had already filed its brief. So at that point, it's there either way. So that's why I didn't actually follow up on having it put in the record. Other than that, if the court doesn't have any questions for me, I'm willing to waive the remainder of my rebuttal. Thank you, John.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. We will now be in recess. We'll, apologies to counsel in the next case, start a little late on that one. I think we'll take a full 15-minute break here and start at about 10:35.